Thank you. I'm Warwick Gilbertson. I practice as a solicitor in New South Wales, and the topic of today's webinar is the issues that arise when our clients approach us to look for and seek advice on how they can care for a vulnerable family member in their estate plan. It's a topic and a question that often plagues us and comes to us from our clients with very deep concerns. And so today I'm going to want to take you through it. And to begin with, I have my normal legal disclaimer. You should also do your own research and seek advice if there are issues that arise with it. But I hope that my talk today will open up many of the issues and the matters that you should consider. So firstly, who are vulnerable persons? Generally, they are, as you know, when a client comes to you, they're a person who suffers from a disability of some form. Our clients talk about their children or family members who are poor financial managers. Some may be bankrupt at the time that they want to look after them. They may have an addiction. It may be alcohol, drugs, even spending. They could be a gambler. They may be someone who is easily influenced, someone who they are conscious of can be part of a grouping or part of an organisation under which they are convinced that their child is being persuaded to do things which they don't think are good for them. They may indeed have a disability which causes them to lack capacity or even have a mental acuity. What I mean by that as to mental acuity to manage is they just mightn't be able to look after their finances. Some people are better than others, and our clients have different views of who is vulnerable and who isn't. So today's discussion is about how trusts can help. And with trusts, we are going to look at both the trust during life, the Inter-vivos trust, and also the testamentary trust and how that can be used to assist and protect family members. But before we go straight into looking at trusts, when a client asks us how they can assist and what options are open, let's look at what could be done otherwise. What are the alternatives to a trust that we are able to guide them through? One of them is quite obvious. You can give a gift, but delay when they're going to receive it. We often, I don't know if your practice is like mine, but I will have parents who think that a child who's 25 can't manage their finances. They may need to be 40. I've also had parents who say they've got a 25-year-old who can't manage, but an 18-year-old who's brilliant. And so there is the concept of delaying a gift before they can receive it. You could, with someone who is vulnerable, actually leave the asset to a trusted adult who will care for that vulnerable person. This is often a means, an alternative where there's not sufficient money to put in a trust. They want to care for someone, but you've got the sister who's very close to the sibling who suffers from a disability. They're very close, they're going to do the right thing. And so the money is given to that sibling, knowing that they can be trusted to care for them. So trust is the key word. Traditionally, there's often what we do, we put a right to reside with conditions on it, whereby the person with a disability can live in the property, and then upon them no longer needing it or passing away, it then goes to what you and I call the remainderman, the other people who go to receive, and so they are provided for. They're all alternatives. There's also, which has come up recently, is the NDIS funding. How many of us have sat down with a client whose child suffers from a significant disability and they can have funding anywhere from 15,000 a year right through to, I've seen them with 350,000 a year. I've seen them with a home dedicated to themselves. And sometimes there's the option of no provision for the child at all because of the NDIS funding. But there is the problem when they turn 65 years of age. And finally, the client can always take the risk, not put any trust in place, not put any protective measure in place, just hand the funds over and say, what will be, I will not be here. They are all alternatives, and in the circumstances may be valuable alternatives. But now let's look at trusts. Where are they suitable? Obviously, where there's sufficient assets, funds, investments available, both during life to be put in a trust and on death. Is there enough to go around? Are there suitable family members available to be trustee? You don't have to have a family member, but commonly with a vulnerable person, they're the ones that you need to choose because they're familiar with the needs of that person and they have a relationship. Do the administrative costs, the tax files reporting, all those things, do they make it worthwhile to put a trust in place? All of that needs to be considered. As I talked about before, what is the nature of the relationship of the trustee who you're considering with the vulnerable person? Remember, they've got to be able to understand and know their needs. And is and will there be a trust deed or will that is well drafted? Nobody wants to end up in the Supreme Court of our states asking the court to give us more powers because the deed or will was not adequate. And particularly, is it unlikely that a will be challenged? Either by that aggrieved family member missing out because you favoured the child or the person who is the vulnerable one. Is there sufficient money to go around, or will they not challenge because of the fact of the provision? Or indeed, will the vulnerable beneficiary challenge because they're upset as to their lack of say? So they are all issues that we need to talk to our clients about. And what types of trusts can we put into being? Look, you can have a trust that you could define as any type of trust, but I commonly use a number of terms which I think we're all familiar with. First of all, there's the beneficiary controlled testamentary trust, where the age of control of when the person receives is delayed, commonly 21, 25, sometimes out to 30, but then they control their own destiny after that. There's an all needs protective trust, which does just what it says it does. It provides all they need. Again, they don't get you delay when they can step in. And it can be either on an age time limit, my slide talks about 25 years, or can even be on death. And what happens then, it cascades to another trust if it's in a will, so that there is an ongoing range of benefits that the vulnerable person can use. You can have what's called a capital protected trust, where the income only is available. And the capital then on the death of the vulnerable person goes to other beneficiaries. You can have a capital reserved trust where the income is received, but it can be supplemented during the year by a variety of ways which are determined by the trustee, and the powers to do so are in the deed or in the will. You can have a thing called a maintenance trust, which does just what it says. It provides for maintenance and the support. You can have a special disability trust, and I'm going to go into this in some detail because this is important with vulnerable persons. You have a special disability trust which opens the door for pension benefits. You can then have something we commonly call a bloodline trust, where the vulnerable person is provided for, but nobody else can be a beneficiary. It can't go to non-blood persons, partners, children, etc. there is a form of protection in that. Or you can have something called a superannuation proceeds trust, which also has advantages. So let's think about the superannuation. Where a person is thinking about setting up a trust, either during life or on death, the funds in the superannuation are available to provide for the vulnerable person. They could indeed pull the funds out during life, a lump sum paid into an Inter-vivos trust, which can be used and for the vulnerable person. Obviously, it depends on the amount of money in the superannuation, but that is an option. The pension that one derives from the superannuation can be used to support a vulnerable person during life, as they would be doing if they were working and their child with a disability was living with them. The superannuation can also be obtained on death, and it can, by a nomination, be paid direct to the vulnerable person, just like they would be as a child. Remember, if they fulfill the definition of a superannuation dependent, it can be paid to them. And commonly we're talking about children, and a child is a superannuation dependent. A nomination can pay it into the will, into the estate on death, and it can then go into the trust and the gifts under the will, and that can go wider than just to superannuation dependents. But if you put it into a superannuation proceeds trust, and particularly one in a testamentary trust, it has great benefits. It receives the death benefit that's paid to the executor, to the legal personal representative. The vulnerable person, if they are, as a beneficiary, a death benefit dependent as defined by the tax law, and I've put the sections of the 1997 ITAA Act in there for you. If they're a death benefit dependent, then that dependent is a spouse, former spouse, a child under 18 years, a person financially dependent, or a person in an interdependent relationship, then those superannuation proceeds are in a protected environment. There are tax benefits to the vulnerable person. It's taxed according to their tax status as the ATO takes a look-through approach. But the superannuation proceeds trust needs to provide for who will receive the capital of the trust when it vests. Superannuation proceeds trusts are peculiar creatures. You should not dabble in them without getting good advice first. It is essential to get advice. So, I've gone through different types of trusts that are available. What I want to talk about now, particularly, are the features of a special disability trust. It is a trust whereby the vulnerable person can receive a benefit but still be eligible for the means-tested pension and the pension card concessions. In essence, the income of the trust is ignored. But to qualify, the beneficiary has to suffer from a severe disability. And if they meet that trust, then what is in the trust can provide for accommodation, support and care, but only for the beneficiary, not for others. You must have two non-professional trustees. Where you put it in a special disability trust, the trust is income taxed according to the beneficiary's marginal rate of tax, and that's a great advantage. But no capital payment is required. Is allowed. You cannot make a capital payment. It's a special disability trust. It gets the benefits, provide the accommodation, a house, etc., and the income provides for the vulnerable person's needs, but the capital doesn't go to them. And this is most important. the terms of the disability trust must meet the requirements of the Social Security legislation. It is essential. Now, I've just talked about a special disability trust. Let's talk about protective trusts and see what their features are. And I'm going to come back to the special disability trust. A protective trust, one of the features are you don't have to worry about eligibility for the pension. There's no eligibility unless the income from the trust is such that your beneficiary, your vulnerable person, meets the income test. There's no assessment in a protective trust where the level of disability is necessary. There's no requirement to meet any level of disability. It's just your client's view of whether their child that is a vulnerable person in their view. The terms of the trust can be flexible and varied. There's no statutory or state requirement that you have to meet. It's just a requirement of the trust and what your client who's asking you to put that in place wants to see. The income and a capital are both available as the deed arrives, and you can have just one trustee. You can have a corporate trustee. It is open for all. The trust income is taxed at the beneficiary marginal rates, and undistributed income retained by the trust is taxed at the trust rate, which we all know is the highest rate. One of the features, however, of a protective trust, it allows other beneficiaries than the vulnerable person to receive something, which might be good. If you're dealing with a child who's an addict, you may want to restrict what they get, but you may want to help their spouse or their children by being able to make provision for them. And also, you can give capital if the trust deed allows or the will allows for it, or it doesn't. It all depends on what is in the will or in the deed. And finally, the administration obligations are less strict. So, different types of trusts, superannuation proceeds trust, special disability trust, variety of protective trusts. Let's think about them. Let's look about. With trusts, where the assets are only available on death, we'll commonly find with our clients, they come from superannuation, through to life insurance, through the home. Then, in those circumstances where they're the only assets available, then of course a testamentary trust is the only choice. And that commonly with people who have a child who suffers from a disability is the scenario that you and I see. And where that happens, a special disability trust being created during a parent's life, really there's not a lot of advantage. If they're receiving their superannuation in a pension phase, they're already not being taxed on it. They can use the home where they live in for their child. They can use their tax-free pension on their superannuation to support their child through life. To put it into an Inter-vivos trust just puts it into a taxed environment when they're in a non-taxed environment. So this special disability trust, bit of a tongue twister, also is more difficult when to meet the severe disability trust with a child under 16 years of age. The test is quite complicated, and in my paper that is attached, that you would have been supplied, in the attachment at the back, it actually sets out all the definitions of suffer from a severe disability and to be a child with a severe disability under 16 years. It's quite complex. So, let's look particularly the requirements for a special disability trust, and I'm really directing this with a testamentary trust. Your testamentary trust in the will has to be compliant with the Centrelink guidelines. How do you find that out? There's a model trust deed that's available on these department's website. You can go there, you can Google it. It sets it all out. It gives you a model trust deed, which you can then particularly look at. And there are a variety of providers to you and I of precedents who will have the trust deed as an SDT trust precedent available. However, you must ensure it is up to date. One of the other requirements is that you are under a special disability trust. The trustee is required to report annually to Centrelink as to the trust's financial situation with statements certified by a qualified accountant. Now, it can't just be any accountant. It's got to be someone, particularly my paper addresses it, a CPA, those who have the necessary qualifications that are recognised by Centrelink to be able to do it. So it's a CPA, it's a member of the Institute of Chartered Accountants or a member of the National Institute of Accountants for Australia to complete those financial statements. It can't just be your bookkeeper friend down the road. And the trust deed needs to provide that the department, Social Security, has the power to request documents from the trustee, that the beneficiary needs to have the right to have the trust audited within the terms of the trust, and Social Security need to have the power to require an audit at the trustee's expense if they wish. All of those are in the model deed and need to be available. Otherwise, it doesn't comply. But there's more. There are other requirements. When it comes to the accountant, that accountant cannot be a family member of the trustee or of the vulnerable person. So you can't have your brother, who's the accountant, who's a CPA, doing the report for the trust for your child. That's not allowed. The statements at the tax returns, the statutory declaration that needs to be filed annually with Centrelink must be done by the 31st of March after the tax year. If you've got to go past that point, you've got to go back to Centrelink and ask for more time. Otherwise, you don't comply. And the the financial statement, I should say, has to include a number of things. Commonly, like a business, profit and loss, balance sheet, depreciation schedule. The tax return needs to be included that goes to Centrelink, and the statutory declaration needs to set out the expenditure that was spent on care costs, accommodation costs, and discretionary spending, and include a declaration that there's no spending on immediate family members, which includes not engaging your grandson or your son to come and do maintenance on the property. You cannot use family members to benefit under the trust. Now, again, in the attachment to my paper, there is a printout from the Centrelink website of the definitions of care cost, accommodation costs, discretionary spending, and where the department says there is very clear what they'll accept and what they won't accept. Remember, it is important that the Special Disability Trust comply with the requirements of Centrelink. So who can be a beneficiary? I've already talked about it. You've got to meet the severe disability test. That test is generally, if you're 16 years and over, receive a disability support pension, an invalid severe service pension. Remember, this can also apply to returned servicemen, to veterans. Part of the requirement is the carer needs to have qualified for a care payment as well. The disability needs to be severe. The beneficiary needs to be unable to work greater than 7 hours a week. There are lots of requirements. If the child is disabled, there's a requirement that the child be profoundly disabled. How do we know whether they're profoundly disabled? A medical report from an appropriately qualified specialist is required. Again, a child under 16 is available, but again, severe disability. And then the department has this interesting feature. The carer for a child under 16 years of age needs to have what they call a carer's rating of intense. In other words, day-to-day, hands-on care of a child, constant care. It's intense, and you need to go to, your clients need to go to Centrelink, investigate it more to find out what they need to do. Basically, there needs to be personal care for at least 6 months or greater for the year, and this all has to be certified off by an appropriately qualified health professional. Equally, the carer needs to certify as to future needs for this child being ongoing. Yes, there's a lot to meet for the requirements of special disability trust. And the concerns for that are these. The definitions of who is eligible is complex. A medical report from the professional is required. Now, it has to be the appropriate professional, just not necessarily the GP down the road. But if the beneficiary qualifies, these are the benefits. A residence can be provided which is ignored for the purpose of a pension assessment. The residence can be put into the trust. You can put into the trust a sum of money for investment that the trust holds, where the money can be used on an ongoing basis, and that sum will be exempt from the pension assessment process. And it varies every year according to the published adjustment. As you can see on my slide, in 2024, the CPI adjusted sum that is available in a trust, in addition to the residence, is $781,500. So you can have a vulnerable child who needs support, their residence, $780,000 in the trust, and they still receive the full benefit of the pension and all the healthcare concessions that arise. And the trust is taxed at the beneficiary's marginal rate of tax. Equally, the other benefit is pensioner donors to that trust, who are immediate family members, may be able to put money in without breaching their pension gifting rules. Yes, they should investigate it, but it's as if they never owned the asset that was gifted for the purpose of their assessment of pension. But there are more. Remember I said there's more to it? Trustees need to be Australian residents. They need not to be disqualified under the Corporations Act. They need no criminal record for dishonesty, no offence under the Social Security legislation or veterans legislation. And the beneficiary and their partner cannot contribute assets to the trust except in limited circumstances. So it's got to be your client and other family members into the trust. These are the tax benefits of a special disability trust. Unexpended income retained in the trust is taxed at the beneficiary's marginal rate of tax, not the top tax trust rate. There are CGT concessions for donating the asset. The main residence exemption is retained, both going in to the trust and coming out of the trust when the main residence is sold. And the trust and beneficiaries' tax returns are completed by the trustee. And there's also, by state law, a stamp duty exemption on property transferred into the trust. Great vehicle for looking after a vulnerable child who meets the definition. A lot on disability trusts. Let's talk about protective trusts for beneficiaries who are vulnerable, who do not meet the severe disability test. What are they? Well, the trusts are taxed as all trusts are, which means the beneficiary's tax return declares the income they receive. That's paid at marginal rates of tax. The trust is taxed on retained income according to the trust tax rate, which is a higher rate. There are annual returns, financial statements are required. All of those are the features. Capital gains tax, state duty applies to a protective trust that is not a special disability trust. So you've got to work through that minefield, both putting assets in and out of the trust. You have to exclude foreign persons if you go to put residential property into the trust, because otherwise you run into the problem of land tax and surcharge duty on land tax and surcharge stamp duty on purchase of a residence if you haven't excluded foreign persons. And you must do that exclusion in the will if the protective trust is a testamentary trust. Remember, if you transfer the home into the trust, that you lose the main residence exemption. You still get the 50% deduction, but you don't get the main residence exemption. So you've got to think about that with protective trust. And the income and capital of the trust will be used in assessing the vulnerable person's pension entitlement. That's not excluded. So, what about some control issues, the things that we have to look at? How do we work this out for the vulnerable person? Well, it all depends on the terms of the trust. There are issues that we need to think about. When does the trust end? When does it vest? Who are the trustees? Who's going to be the appointor? Is there going to be a protector? And I'll deal with that later on. So, who are appropriate persons? There are all issues to talk to your client about. What are to be the powers of the appointor or the protector? Is the appointor going to only get rid of the trustee or put in another trustee? Or are they going to control capital payments out? Or what are their levels? What are their roles? They are all issues as to control. They're matters to be discussed. As I said, is there appointor to consent to the income and capital? Does the appointor or a protector consent to distributions to wider family members? Must the trust apply only to the vulnerable person unless the appointor agrees or the protector for it to go to other ones? What are the requirements to consult the vulnerable person, the beneficiary? What do you put in about that? And most important of all, what are the requirements of the amendment of the trust deed? And does the trustee have full power to amend? Do they need a acceptance and consent of the appointor? And if we have someone else as a protector, is that person also to consent? And on what basis? The amendment is important because most trust deeds, when they really run into problems on the amendment of the deed. And if you go to the case law, you'll often find that it is a challenge to the amendment of the deed that causes the matter to come before the court. So clearing out who's involved, what is necessary, crucial control mechanism. So that's why I've talked about it. And by the way, with the amendment of the trust, what role does the vulnerable person say? Do they have a role of saying, hey, yeah, we can change this, but I need to also consent? What's the nature of the disability or the incapacity or the vulnerableness of the beneficiary that your client's seeking to protect them against? What is it? So where you create a trust and you put all the terms in it, you need to remember that there are rights that the vulnerable person has. And beneficiaries have rights. Firstly, It's a very obvious right. They have a right for the trust to be administered in accordance with its terms. Now, there has been lots of case law about this. And again, the terms of the trust need to set out what that is, what the consultation process is, what are the powers of the trustee. Are they able to advance capital for the purchase of a home, for going overseas to a trip on a regular basis? Is it to have a car? Is it to have education requirements? Is it to have some form of nursing that's involved? What is it? You need to be very explicit in your trust deed about these terms. And the more explicit you are, the more the beneficiary is able to say they want the trust administered in accordance with its terms. The beneficiary is able to express their wishes and to ask for assistance. If you look at a number of the trust deeds that are out there from providers that are protective, you will see that in the powers, there is a requirement of the trustee to consult and to talk to the beneficiary on specific times. And indeed, the case law says that if a trustee is to make decisions for a beneficiary, particularly a vulnerable beneficiary, then they need to understand the needs of that beneficiary. So asking for assistance is important. The beneficiary can require the trustee to account and explain decisions, although where there is a discretion completely unfettered, that may not play out. But commonly with a all needs protective trust, with a capital protective trust, with things like a special disability trust, definitely the trustee can be, beneficiary can require the trustee to account and explain decisions. And remember that the beneficiary has a right to seek court intervention, to go to court if they are of the opinion that the trust is not being administered as they would see fit. And indeed, a person on their behalf can do that as well. Trustee has rights. The trustee has the right to have their reasonable expenses paid. A trustee has a right to seek judicial advice if necessary. If your trust is not clear, then they have a right to ask for an explanation and for the judge to indicate what is. They're entitled to receive recompense for their actions if the deed allows. What does your client want to put in? You know, if a trustee is going to be a trustee for a long time, they're going to be doing this out of love and affection for the rest of their time. Unlikely. There needs to be some form of recompense. The trustee has a right to appoint additional or replacement trustees. Indeed, even the Trustee Acts of our various states set out how that can occur if the trustee is silent. A trustee has a right to decide how funds are spent, again, according to the terms of the trust, and to invest as the trust deed permits. And they also have the right to obtain professional advice at the trust's expense. But they have obligations. There is the obligation to keep accounts, to be ready to account for their actions to the beneficiary. And that is very important. So a trustee just can't make decisions in their head. They need to have paper trails. They need to have things in place where if they're called to account, they can do it. So being a trustee, there are rights and there are obligations. So again, the choice of who is a trustee becomes important. Now remember, the topic of today's webinar is how do you provide for a vulnerable person? And so vulnerable people are often under that term because they can be influenced. So when you're advising your clients of how to deal with that, how do you deal with undue influence? What is it to start with? Your view and my view of undue influence may not be our clients. Often our clients' view of undue influence is they don't like the influence of their child's partner. They just don't get on with the partner, or they think the partner's wrong. Or the child may be involved in a religious organisation or some form of group with beliefs or requirements that your client is opposed to or considers are not really right. So what is undue influence? It's been defined, but commonly undue influence, as far as the law is concerned, is coercive behaviour both towards the trustee and the vulnerable person. Now, it doesn't need to be like my slides got, that you've got your arm twisted up behind your back. It can be a variety of things. Coercive behaviour can be very innocent. It can be as far as, oh, don't do that to him, or don't do that to her. Why would you do that? That's not what mum would have done. There's all sorts of, how far is it taken? What is the persuasion that is coercive? The persuasion and the influence that is coercive is when it operates on the trustee or the beneficiary's mind to such an extent that the decision is no longer free or independent. So, as I said, it may not be intentional. It may appeal to family ties, affections, and emotions. And it also can be conduct that causes a decision to be made by the trustee that's not really what the trustee would have wanted to do. It's something that they're doing because the family makes them do it. Accordingly, you need to talk to your client about how they deal with that issue. Undue influence needs to be dealt with. Be upfront with your client about the issue. Ask them, how do they think they want to deal with it? Think about the trust terms as to the powers, the discretions, the consultation that is there or put upon the trustee that will keep the trustee free and not necessarily being controlled themselves. The trust deed should ensure, and the trustee should ensure, that they keep good records as to the decisions made. But there's a caveat to that. Remember, if there are recorded reasons for decisions, then they're capable of being reviewed by the court. Where there are no reasons, there's simply a recorded decision. That's another factor. But if the trustee sets out why they did something, a court is able to review whether that was a wise decision. You can appoint a trustee and an appointor who cannot be easily manipulated. The person who is mentally strong, who can resist the emotional pressure, who can look at the long term or the real needs, who can has a relationship sufficient with the vulnerable beneficiary to be able to talk to them and explain to them and to be listened to. So they'll be able to act fairly, but protectively. They'll be able to stand up to the pressure that would otherwise be advised. And they understand their powers and discretions that they have under the form of the trust. Also, they need to be aware of the vulnerable person's susceptibility to influence. So the choice of a trustee is important. And you need to consider, if you can't find an adequate family member, someone who is independent, who can be a protector, or you can have multiple trustees, so that you might have two or three, two where you make the decision and one who can really be an advocate for the vulnerable person. The appointment of the trustees and the appointors are crucial. And that's because there are keys to success when we are advising our clients as to how to put in an estate plan, a trust, or a terms in a will that will actually work. So what are those keys to success? Let's summarise. Obviously, appropriate persons to be the trustees and appointors. That's singularly a key. Our case law is littered with trustees who have been appointed, who become biased, who become vindictive, who don't act properly, and in the end, they need to be removed or they are held to account. Choice of appropriate persons is key. The trustees, when appointed, have to have a supportive, trusting relationship. This is more so than in any other form of trust. When you are dealing with a vulnerable beneficiary, there needs to be a two-way street, a supportive, trusting relationship. Yes, you could, if you have a client with sufficient assets and wealthy enough to appoint a trustee corporation, you could have one of those companies being the trustee. But if you go to them, you'll usually find they have a particular person who will create and work on developing a trusting relationship with the vulnerable person. The trustee must act in good faith and after considering all the facts and needs of the vulnerable person as the trust deed permits. They are not to act in a particular biased way unless the deed says they can. Now, obviously, a special disability trust says they have to act only for that vulnerable person. But varieties of protective trust deeds may allow for other actions. So, again, it depends on who you appoint, and the law says they are required to act in good faith. They are required to do this, and if they fail to do it, if they fail to act in good faith, if they fail to consider all the facts and need, even where they're given wide discretion, we have cases where where courts have removed trustees. You all may have recently remembered and talked about the 2022 decision in Victoria we call Owies case, OWIES, where the trustee ceased to act in good faith, was blind to all the other facts and needs of their siblings, and the court removed them, even though they had wide discretion. The keys to success are maintaining financial and trust records, and that includes decisions that have minuted, particularly if you're a corporate trustee. Remember, if you're a trustee, a personal trustee, yes, trust decisions. If you're a director of a corporate trustee, then there are the requirements of the Corporations Act. There have to be minutes of the meeting. There have to be minutes of the recorded decisions by the company made at a directors' meeting, both as to the financials and also as to the provision made for the vulnerable person. So that is important, and where directors of a trustee corporation who are family members, so it's really just a corporate shell, the court will, in looking at whether they have acted fairly and properly, will look at their process. And so the records and the minuting of decisions within the company become important. Again, remember, trustees' decisions and administration of the trust is able to be reviewed by a court, both where the beneficiary is able to do it themselves or somebody who is the next friend or the tutor or appointed to act on behalf of the beneficiary. So in conclusion, I'm conscious that time is passing. In conclusion, let's look at things. If you haven't already worked it out, the drafting of the trust, that is the Inter-vivos trust, and the will requires care. Beware just taking a precedent that you've got on your system and plugging it in and say, this will work. You need to think about your own client's particular individual circumstances and the vulnerabilities that they wish to protect. Remember also, it's not just putting in place a trust or a will. There are tax and stamp duty implications. And I've talked about the super proceeds trust. I've talked about the special disability trust. I've talked about ordinary trusts where we have residential property, where you've got to think about excluding the foreign person. Think about the tax and stamp duty implications. Remember, the Special Disability Trust has pension concessions and capital gains tax exemptions, both going into the trust and coming out of the trust. They are crucial and very important. A testamentary trust, also at law, has capital gains tax rollover. It has other benefits of income taxes, how you do it through to the beneficiaries and within the trust. There are stamp duty benefits on transferring assets, and also with a testamentary trust on income-wise, with infant beneficiaries, there's what's called the accepted trust income, where it can be distributed to infants at the marginal rates of tax. A testamentary trust, particularly with a parent who has the home, significant super, and that's about it, it does enable a parent to care for their vulnerable child during life. And most of us see clients who come to see us at a 70-year-old who's got or an 80-year-old who's got a 50 or a 60-year-old child who suffers from a disability, and they're wondering how they can care for them. A testamentary trust enables that parent to care during the person's life as they choose, and then with a special disability trust particularly provide for care on death. Again, trusts create obligations that last for years. So when you do your trust deed, when you're looking at people, trustees' succession is crucial. Who they going to hand it on to? Who are you appointing? Don't appoint my older brother Bill, because if it's your client who's going to pass away and older brother Bill is the executor, what's the point? You need to look at succession going forward, and you need to look at within the deed, as I've talked about, or within the will, who will be able to come in, who can amend it, what can be involved. Except remember, with special disability trust, that is even more important, because you must always have two trustees that are there, two people who are Australians. And finally, beware with testamentary trusts of family provision claims. There is a necessity with wills that there is adequate provision made for the children. But equally, when you do the trust in the will for the vulnerable person, the trust has to make adequate provision both as to the sum that is put into the trust, as to the manner in which the trust is to operate for their benefit. So the terms of the trust become crucial. Your provision is not just I'm whacking in 50% of my estate to the child for the child's benefit in the trust. The trust actually is framed in such a way that it adequately meets the vulnerable person's benefit. If you don't do that, then there could be claims under the various family provision legislation that we each have available in our various state jurisdictions. So there's a lot involved when a client comes to you and says, I have a child that is particularly vulnerable. What are my options? that I owe for me. How can I care for them? I hope that today has opened your eyes, that it's given you alternatives. It's made you more aware of the issues can arise. I note that there has not been questions that I've gone through. I hope that's because I've answered and met what you wish to know about. So my thanks.
Thanks so much for that, Warwick. Just to our delegates, we do have a minute or two available to answer any questions that you do have. So if you'd like to send any questions through, you can submit them via the Q&A button to ensure that they're answered. We'll wait for a few moments to see if any questions do come through.
I found I've often, Lisa, a lot of people find it nervous to ask questions because they're wondering what the answer, whether they really got to understand what was going on. This is a judgment call in all these matters. There's no one answer fits everything. It's always a judgment call.
Thanks for that, Warwick. Well, it doesn't look like we've had any questions come through, so I will close the session there. So I do want to thank you again for an excellent session today, and thank you everyone for participating in today's event. You will be redirected to our online exit survey shortly. We ask you to please take a moment to complete the survey as your feedback is very important to us. We thank you in advance for your feedback, wish you a pleasant afternoon, and hope to see you at another event by Attend the Education Network soon. Thanks again, everyone. Bye now.